This guy is without a doubt one of the most arrogant customers that our dear Judge DeSanta has ever had. Yeah, I did say DeSanta. If you know the joke, you know the joke. And you won't believe the way this guy talks back to the judge. And knowing her, she's got a good quip for him. This guy literally argues like a 14-year-old boy who thinks he knows everything.
Please state your name, sir. Jordan, me.
Okay, thank you. Are you picking them up, Lynn?
Yes.
Okay, thank you.
Thank you.
All right, and so counsel, I'm just going to make this statement that I know that there are 3 defendants.
Correct.
Mr. Shumke is representing Mr. Mosier. You are representing Mr. Mead, and so we are going to have a 3rd attorney for Mr. Fritz. If Mr. Fritz is here on a day that both you and Mr. Shumke are here. So I just wanted to make that, I just want to state that for the record.
May I ask, Your Honor, does the court know why Mr. Fritz's matter was adjourned from 10 o'clock this morning?
I don't know. I haven't looked into it. I just noticed when you asked if it was still on the docket, because the docket you had showed he was on the docket, and today's docket does not show that. I did not look into that any further. I did not. Perhaps he has retained counsel. I don't know.
That is an accurate statement, though, Your Honor. There are 3 co-defendants.
Okay. And so the court, counsel, as to arraignment.
Your Honor, I advise my client of the nature of the charges against him. Next becomes involved. He understands them as to both counts. This time we'll wait for a reading stand.
The court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment, and counsel as to the pretrial.
Your Honor, I've had conversations with the prosecutor and with Mr. Shemke, who represents one of the co-defendants. I understand Mr. Shemke set his matter for a second pretrial for discovery purposes. Obviously, we may have common discovery, so my client's asking for a jury trial, but he believes, as well as I do, that a beneficial final pretrial date would be in order. I understand the May 31st. I'm going to be here. Mr. Shemke's going to be here with his client. If we could have that date as well, Your Honor.
Okay. And did you need a discovery order, counsel?
Yes, I probably should have one, Your Honor, because I don't know what Mr. Shemke's going to discover. I may need my own in the future. I don't know.
Okay, so I'll need a discovery order from Mr. Carmen so that I can sign that.
All right, I'll get it. Do you want to announce it, Your Honor, or do you want to, we'll get it now?
I'll do it afterwards. That way we can continue with bond.
All right.
Okay. And we'll adjourn this matter for discovery purposes to May 31st. Did I do 9:30 or 10 o'clock? I don't remember what time I did. Do you have it written down? What time I did or no?
I'm here the whole day, Your Honor. It doesn't matter to me.
And counsel,
10 a.m.
I'm sorry?
May 31st, 10 a.m.
Yes, and counsel as to bond.
Your Honor, my client, as you know, other matters pending. He's not on probation or parole. Your Honor, he is not presently working due to a medical condition. He may be applying for Social Security disability, but at this time he's not working. So we've asked the court to consider a personal bond or a bond he can reasonably expect to post. He has no money today. Is that correct, sir? That's correct, sir.
All right, and sir, are you currently on probation or parole anywhere?
No, ma'am.
Ever failed to appear in court for any reason?
No, ma'am.
You're most recently on probation in this court, correct?
Yes, ma'am. That's the only time I've ever been on probation.
He successfully completed that. Is that correct, sir?
That is correct.
Yes, but not the first time that you've been charged with this type of offense. So, if you were to test today, what would be detected in your system?
What would be detected in my system?
Yes,
I mean, like drugs,
anything,
Is that
drugs,
what you're
alcohol, anything.
marijuana.
Do you have a valid prescription for marijuana?
No, I recreationally smoke.
Okay, moving forward, you cannot. Okay? When's the last time you used any marijuana, sir?
On the way here
On the way here,
this morning. Yeah.
in your vehicle?
No, at home. On the way out the drive, walking to it.
Are you under the influence of marijuana now,
I
sir?
am not under the influence.
You understand the proceedings in this court happening
Yes, I'm
today,
very
what we
aware.
talked
Hold
about?
on, only one can speak at a time, Mr. Meek. Okay, so please let your attorney finish asking the question before you answer.
Imagine ratting on yourself like that. Now, the argument as to whether or not he's under the influence becomes a big deal here in a minute.
Sure.
When we had a conversation, were you able to understand all the rights and rights and things that we talked about?
Yes, sir.
I'll leave it to court's discretion. I
Sir,
think he's competent.
okay, let me just indicate, did you drive here?
No,
Who drove?
a friend.
You didn't drive here.
No.
And which friend drove you here?
That's not related to my case.
Mr. Mead, if I may, Your Honor.
Sure.
We talked about
Mm-hmm.
the questions the court may ask.
Mm-hmm.
All right, is that yes?
Yes.
So understand it, as a condition of your bond, the judge wants to make sure you're following all the court's orders. As one of them being not to operate a vehicle if you don't have a valid license.
But I have a valid license.
You may have a valid license, but you are still not permitted to operate a motor vehicle if you're under the influence of marijuana. That is my
I'm not
question.
currently under the influence of marijuana. I've been here for like 5 hours.
I understand that. I understand that's what you already indicated to your attorney,
Okay.
but you got here at 7 a.m.
At 9.
Okay, so that's 3.
It feels like a lot longer. But
Okay.
I'll take that.
I'm
Yeah, it probably feels like a lot longer because I bet time feels like it was going slower because you're blazed. Not that I have a problem with that. Frankly, I do not. I am pro 420, but not just before driving.
I can understand that, sir. And we had a case that took quite a bit of time that was not expected to take. So I apologize for your wait today.
Thank you.
But I'm also going to indicate that if you use marijuana, you cannot get into a vehicle and drive.
For how long?
Well, as long as you are under the influence of marijuana.
Okay, I understand that, and I'm not under the influence of marijuana.
Okay, but I also don't appreciate you lying to this court and telling me you did not drive here.
Did you see me drive here?
Well, it's a bit late to try to use that card now when you just told her you drove
I'm
here.
not sure why we're just so hung up on this.
Because it's a condition of your bond.
Because I have a duty to protect the public, sir.
Yes, ma'am.
And if you're using marijuana and then driving,
I am not.
I have a duty to explain to you and reiterate to you the law that says you cannot use marijuana and then drive.
I fully understand that, ma'am.
So I do not appreciate the disrespect that you are showing this court.
There is no disrespect, ma'am.
What kind of car do you drive, sir?
I drive an Escape.
And what color is your Escape?
It's white.
And is that out in the parking lot?
Yeah.
Okay, so as I suspected, you did drive here. So I do not appreciate being dishonest to the court.
Okay. But I'm also not under the influence of marijuana, which is what you seem to be so hung up on.
Yeah, when she does that face, you're probably doing something wrong. Not the way to talk to this judge.
Sir, as I indicated, I have a duty to protect the public.
I understand that.
If you think that this court is hung up on the fact that you used marijuana and drove, you're correct.
Mhm.
That's a problem. That's illegal.
Right, but you don't
So,
know the time
excuse
frame
me.
between the two.
Excuse me, don't interrupt me.
I'm just gonna remain silent.
I am hung up on making sure you understand the law that says you cannot consume marijuana, be under the influence of marijuana, and then drive a vehicle.
For how long?
Just as though you cannot consume alcohol, be under the influence of alcohol, and it affects your ability to operate a motor vehicle.
Right.
How long is determined based on individuals, based on consumption. I don't know how long, sir. I cannot give you a time frame. I'm just telling you that you cannot use marijuana,
Mhm.
be under the influence of marijuana, and then drive a vehicle.
Absolutely, that sounds horribly irresponsible.
So if you think this court's hung up on it, you're correct. I need to make sure that you understand that.
Oh, I'm well aware. You've made it clear. Thank you.
The court's going to indicate a $5,000 personal bond. You're not to possess or consume any alcohol or drugs unless prescribed. And you're not to have any assaultive, threatening, harassing contact with the other co-defendants.
Wonderful.
He has no reason to have contact with them, Your Honor, but I may have to share contact with Mr. Shemke through his clients, the court committee, that, of course.
That's correct.
Thank you.
All right, we'll see you back on May 31st. The court's going to go off the record, so counsel, I can make sure that we have a third attorney here on that matter.
Thank you, Your Honor.
So there we have it, lads and lassies. This guy was without a doubt one of the most painful people I saw yesterday. But by God, did he pick the wrong judge to do it to? You know, she's no nonsense. He's actually very lucky he didn't get done for perjury or get a contempt of court charge tacked on to everything else. Because lying to the judge, then admitting it, and when she questions him about it, talking back to her like that, not a good idea. Anyway, folks, I hope you enjoyed the video. There's a good chance that this video will be demonetized because of the subject matter. If it is, consider dropping a like, comment, share, or tip into the PayPal tip jar, become a member, whatever. Talk to you soon, folks. Sláinte.